Hi, I'm Alison Symington. I'm a senior policy analyst with the Canadian HIV/AIDS Legal Network. In Canada, people living with HIV have a legal obligation to tell their sexual partners that they are HIV positive before having sex that poses a realistic possibility of HIV transmission. This legal obligation dates back to the mid-1990s, but it was made much more strict by a Supreme Court decision in October of 2012. According to the court, people living with HIV must reveal their HIV positive status before having sex that poses a realistic possibility of HIV transmission. If they do not tell their sexual partners that they are HIV positive, they could be charged with aggravated sexual assault, a very serious criminal offense. This means that you could go to jail if you do not tell your sexual partner that you have HIV, even if the virus is not transmitted. The Supreme Court ruled that people living with HIV have to tell their sexual partners that they're HIV positive before having sex that poses a realistic possibility of HIV transmission. But they characterized almost any risk as a realistic possibility of transmission. So what this means in practice is that if you're going to have vaginal sex without a condom, you have a legal obligation to tell your partner that you have HIV. If you're going to use a condom and you don't have a low or undetectable viral load, you also have a legal obligation to tell your partner that you have HIV before you have sex. It's only if you both use a condom and have a low or undetectable viral load that there's no legal obligation to disclose. Viral load is the amount of HIV in your blood. It's measured through a blood test that's ordered by your doctor, and HIV treatment is designed to lower the viral load. The Supreme Court was clear that people living with HIV do not always have to tell their sexual partners that they're HIV positive. If you're planning to have vaginal sex, you're going to use a condom, and you have a low or undetectable viral load, you do not have a legal obligation to disclose. The combination of using a condom together with a low or undetectable viral load removes the legal obligation to tell your partner that you're HIV positive. In its 2012 decision, the Supreme Court did not say anything about anal sex. The risk of HIV transmission for anal sex may be higher than vaginal sex, so we know the legal obligation would be at least as strict. What this means in practice is if you're going to have anal sex and not use a condom, you would have a legal obligation to tell your partner that you have HIV. If you are using condoms and you do not have a low or undetectable viral load, you would also have a legal obligation to tell your partner that you're living with HIV. But because the Supreme Court did not say anything specific about anal sex, we do not know if the combination of using condoms and having a lower undetectable viral load removes the legal obligation to disclose as it does for vaginal sex. At this time, it isn't clear whether there's a legal obligation to disclose HIV status before oral sex. Oral sex is generally considered to have an extremely low risk of HIV transmission. It is clear that before kissing and other activities with no risk of HIV transmission, there is no legal obligation to disclose your HIV positive status. This legal obligation applies to all people living with HIV in Canada. Disclosure is difficult and complex. As a person living with HIV, it's important that you know what the law requires so that you can make informed decisions about your life. Please visit our website for more information about this issue and for updates as the law develops. The Canadian HIV/AIDS Legal Network has many resources available for people living with HIV, for service providers, and for lawyers, so please contact us. Thank you.